Hello friends, Mandar here. I'm back with another video. Today we'll talk about some of the updates from USCIS that are impacting not just employment-based petitions but also family-based petitions. We'll also talk about some IRS frauds that will impact your green card or naturalization. We'll talk about the upcoming proposal to get rid of the H-1B lottery and instead replace it with wage-based H-1B selection. It has a huge impact. This has come in the past, but it never turned into effect. But this time, it has a chance of getting into effect. We'll talk about the feud between this administration and India and its impact on Indian citizens and students here in the United States. And finally, most importantly, we'll talk about the September 2025 visa bulletin. What are the changes and what can we expect in the upcoming months in the fiscal year 2026? So a lot of important topics, guys. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now check out the links in the description because those are affiliate links and you might find something interesting, especially the Ultra Human Ring, which has been benefiting me for a long time. You'll get 10 to 15% discount if you use the coupon code MANDAR10. Also, I have some classes and I have some links in the description where you will be able to connect with me to discuss your situation with me and get my perspective on what I would do if I were in your situation. I haven't been able to make any videos in the last month because I was sick and I also was traveling. So pardon for that. So there are a lot of topics that are pending. So let's jump into it. Now, just so you know, there are a lot of my audience who are also in the family-based section. So when I cover some family-based topics, some people get upset. There are people who are in the 130 petition as well. And there is some high scrutiny on how they came into the United States. Now, 130 petition is for people who are immediate family relatives such as wife or children or spouses. And in itself, 130 does not give you any immigrant benefits, so just like 140 doesn't give you any benefits. So keep that in mind because some people assume that just because you have an approved I-130, you are safe. You are not safe because you will still need to apply for 485, for which your date has to become current depending on the category you are in. And it also depends on how you came across the border or how you came into the United States. It matters a lot, especially during these times. There are a lot of sensitive topics that have started to come up in my way. And although I'm not an immigration lawyer and don't specialize on the family-based sector, there are a lot of NTAs that are being given out for people who are being approved of I-130 but who had some background check issues. So consult a good immigration lawyer if you are in that situation. Now you have been seeing a lot of guidances from Trump administration. One of those guidances is keeping men away from the women's sports. And that is something that has been pushed out. I'll put an update on the screen, but this means that there are some regulations that are being passed that are going to impact your entry into the United States. The third important point for today is the update to the Child Status Protection Act. Now, what is CSPA? CSPA means if you have children who were not born in the United States and if you are an immigrant here and if you have a green card petition for yourself and your entire family, including children under 21, they are on your petition only until they turn 21. Once they turn 21, they cannot remain as a dependent on your immigrant petition. So that is where this comes from, the CSPA comes from. So what happens is if somebody comes as a child along with their parents, and if you are from a backlog country like India, you have decades of wait. It means that even by the time you turn 21, you may not have your green card approved. So this will put you in a difficult situation right after your 21st birthday. You may have to find a different visa category to remain in the United States. There are different strategies that I talk with people, especially students who are just about to turn 21 and who are on their parents' petition on their green card.
And that brings me to the sponsor of today's video. Have you ever done the Google search of your own name? Look what I have found when I did mine. Here's what comes up. While some of this information is relevant, the other makes me uncomfortable that my information is exposed for a sale like this. Data brokers sell your information to scammers, spammers, or anybody else who may want to target you. Your full name, email address, home address, your relatives' names, health information, it's all out there. That's why I have been using Aura, sponsor of today's video. Aura shows me which data brokers are selling my information and automatically submits opt-out request for me. Cleaning up my information not only helps reduce the amount of spam I get, but it also protects me from hackers who could use this information to help them access my social media accounts, bank accounts, or other sensitive information. Aura does so much more to protect my information and my family's information from online threats I can't see. I get other features like antivirus, VPN, password management, parental controls, identity theft insurance, and more without having to download several different apps. It's really easy to set up, and best of all, I get everything for one affordable price. You may already have one or two of these tools, but not having Aura is like locking the front door but leaving your back door wide open. Aura is always on, doing the hard work of keeping me safe so I can focus on other tasks with peace of mind. I value my privacy and I value yours. You can go to my link which is on the screen and in the description and start your free 2 weeks trial. So protect your information, your family, and have a peace of mind. That's Aura.
Now CSPA allows you to recapture some of the time that your parents have spent or the primary applicant has spent on their pending I-140. So if the I-140 was not filed in premium, the days that the petition was pending, those can be deducted from your age so that you will still be under 21 years of age. Now, in the past, prior to 2023, final action chart was used for this purpose, for the calculation of CSPA. Then Biden administration changed it to use data filing chart, which was actually in the benefit because data filing chart is actually further ahead, at least 9 months to 1 year ahead of the final action chart. But now the Trump administration is reverting back to the final action chart just like it was before 2023. Now this is what they have come up with. USCIS updates policy on CSPA age calculation. This came out as a release date on 8/8/2025. We are updating the policy manual to clarify that a visa becomes available for the purposes of Child Status Protection Act age calculation based on final action dates of the Department of State Visa Bulletin. The new guidance applies to request filed on or after August 15, which is already passed. We will apply February 14, 2023 policy of CSPA age calculation to adjustment of status applications pending with USCIS before August 15, as these aliens may have relied on that policy when they filed. So what they are saying is the policy that Biden administration had put together on February of 2023 to flip over from using data filing chart will still remain into effect for petitioners who had filed their petition before August 15, 2025. So anybody who is filing after August 15, 2025 will have to go back to the CSPA calculation based on final action chart. So this is a significant change. It reverts the Biden administration policy to what it meant before February of 2023. If you are impacted by this and if you have any specific questions, contact me and I will let you know what my thought is on your CSPA calculation for your children. Now there is a lot of news regarding revocation of green cards and denaturalization in the news, and I myself have covered this topic in multiple videos in the past. Now you have to remember, unless you have a big problem in your background check, you don't need to worry about it. Typically in green card process, you have to be truthful, you have to be not misrepresenting while you got your green card. If you got green card by fraud, by marriage fraud, by any other fraud, or by concealing some information that would have impacted the outcome of you getting a green card, then you will have problem in your naturalization. So even if you are naturalized, and if they determine later on that you had obtained naturalization or green card through fraud or through concealment of any of the information, you are at risk. One more point that they have emphasized is the tax fraud. Now, if you had done any tax fraud or you have high dues in tax returns from IRS, if you have not paid your taxes prior to becoming a US citizen, you might be impacted and they might that will be a cause of ground for your denaturalization. So pay close attention to it. So when you are in the United States, however long you are, you should have a clear tax record. You should never have missed your tax returns or paying the taxes to the IRS. Now, this is important to note that this fraud will only impact you if you had done it if you have done it before getting naturalized. After getting naturalized, they are not saying anything about denaturalization. Not to say that you should always file your taxes on time and all the taxes that you owe to the government. That's a given. But from the immigration perspective, you will be penalized if you did a fraud before becoming naturalized US citizen. It might come back to haunt you later on. So pay your taxes on time. Although no brainer, that is my suggestion. Now, how does this come up? There is a question 15A on N400 naturalization form. If you look at it, it is a vague question. It just says that have you committed any fraud or have you committed any violence or have you committed any violation for which you were not charged or arrested? And it's a very vague question. And this includes everything. When you say fraud, it can be any kind of fraud, including tax fraud. So if you have said no and if you have gotten your naturalization and later on USCIS determines that you had committed IRS fraud or tax fraud prior to becoming a US citizen or applying for N400, they can hold that against you. So that is the point. Now there is going to be a change in the way H1s are given out. Now, as you know, H1 is a lottery system since many years. Anybody who needs first time H1B has to apply for an H1B by a certain time frame, which is 31st of March or 1st of April of every year. So there is a certain quota, 65,000 H1Bs that are given out every year, plus 20,000 for master's program or students who are master's degree from the United States. So total of 85,000 H1Bs are given out. And this is a purely lottery based system. So you put your name in, put your application in, they will run a lottery and they will pick your number or pick your application for a full application profile. So that is what the current process is. So it's a luck of a draw whether you get your H1 or not. Going forward, what the proposal is that it's going to be a wage based H1B. So they will have multiple tiers. I guess there are going to be 4 different tiers under which you will need to qualify in terms of your wage in order to be approved for an H1B. So this was a proposal that came back in 2020 in the previous administration. It did not go anywhere because then it was squashed, but now it's coming back. I think the administration has learned from its past mistake, and it's highly likely that this might change in the upcoming H1B cycle. So in H1B cycle 2026, I would expect some kind of a change from a lottery-based system to wage-based system for H1B. Let me know in the comment section below what you think about this. What are the pitfalls? What are the pros and cons of this new approach based on wages? Now, I just want to remind that this is not in effect yet. It will go through the federal registration publication that is going to be expected soon, launching the public commenting period, which is typically 30 to 60 days. Then it also DHS will need to publish a final rule for this by a certain date in time for the FY 2027 rounds of H1B selection. Now, a lot of immigration rules are being reverted from the previous administration to the new administration, such as temporary protection status for Haitian and Cuban immigrants is going to be ended, and that is going to be a lot of impact to a lot of people, which the previous administration had led them in. By just so you know, this is by statute. This is by the congressional authority. There was a law passed way back which allowed the current any administration to allow certain number of people from countries that are impacted by war or natural calamities to come into the United States on a temporary basis. So it was totally at the discretion at the president. So now they are taking away that facility for TPS status for Cubans and Haitians. Now there is also another news which is kind of interesting, that there is a 15,000 bond for visitors from certain countries. Though I will not name the countries, but the concept is if you are coming to the United States on a visitor visa, the US government expects you to abide by the rules of that visa and leave the country before the expiry of that visa. So in order to enforce that, what they are saying is you need to pay a $15,000 bond, so that you keep that as a security deposit towards USCIS or US government. And if you are in good standing, if you leave the country before the visa expires, you can get that amount back. So it's an incentive for getting your amount back. Now, I don't know if it's going to help detract the fraudsters who are coming here to overstay. It's to be seen, but that's something they're putting in place. There is also a really bad sentiment between the US and India in particular right at this moment because of the tariffs that have been imposed on India. So as a result of that, there is a lot of chatter about how Indians are going to be impacted that are coming into the United States for work, or the students from India that are already here searching for work. Essentially, the administration is asking the technology companies to not hire Indian citizens, which is kind of weird. I don't know how and to what extent this will be a threat to the people who are already here. One thing I wanted to actually emphasize is for students who are coming here for study. Now, in the past, it was much easier. Just get an admission. I get your I-20, get your visa approved, visa stamp for 5 years, come here, study, and get a job, right? So it was pretty straightforward. But now it's becoming increasingly difficult for people to find their first job. Now, especially when you are doing your master's in the United States, and if you don't have any prior experience, it is becoming increasingly hard to find your first job. So I always tell my audience, whoever is coming from India to study in the United States, get some experience back in India. After your bachelor's degree, get some experience, at least 2 to 3 years of experience, and then think about coming to US for masters. That way you will have some experience plus your masters in order to compete for your first job, and that will be it will put you in a better situation to get your first job. So that is something that I would highly encourage to talk to your folks back home, whoever is planning to visit US. Moreover, there is also going to be changes in the rules in terms of how much is going to be the validity of the visa or exchange student program visa that is going to be given in the future. It might be a reduced term and not just blanket 5 years. So H-1B approvals and extensions are becoming a little bit tougher, and there are a lot of reasons for that. One of them is the wages. If your wage does not reflect the LCA, I have seen people getting denied for their extensions. So keep that in mind. There are several other factors that are impacting H-1B extensions as well as we speak. So make sure you are on top of the requirements of what the extension actually means in terms of salary, in terms of location, in terms of client location, in terms of client visits, in terms of stamping. Make sure that everything is clean before you apply, because you don't want to be in a situation where you have passed your I-94 date and your extension got denied. That will put you into a very difficult situation unless you are in 485 stage, which will give you a period of authorized stay. People who are getting laid off, they are in different variety of situations. There are different options for you. There are a lot of people who are contacting me who are getting laid off. Every situation is different. So if you need my opinion on what you should do, or what I would do if I were in your situation, contact me on Calendly. I'll be happy to look at your situation and suggest you some things. Again, this won't be a legal advice, but it will be a practical advice based on my experience. Now, finally, let's look at September 2025 visa bulletin, and also I'll jump into what my speculation is for the upcoming FY 2026 visa bulletin progression. So as you can see, on the left hand side, I have August 2025 visa bulletin, and on the right hand side, I have September 2025 visa bulletin. Now first, let's look at the family based section, which is the final action chart, which is chart A. If you look at F1 category is exactly the same. I don't see any date changes in the F1 category for final action chart. F2A is also same for all chargeability, same for China, same for India, and same for Mexico and Philippines. No changes in the dates for F2A category in the final action chart. For F2B, again, I don't see any date changes for all chargeability China and India, but for Mexico and Philippines, I am seeing some progression. For Mexico, it's from 1st of January 2007 to 1st of April 2007, and for Philippines, it's from 15th of April 2012 to 1st of May 2012. So a little bit of a progression there. F3 category is the same for all chargeability China, India. For Mexico and Philippines, for Mexico it's the same, but for Philippines there is a progression from 1st of December 2003 to 1st of May 2004. F4 category January 1st 2008 is the same for all chargeability China. For India it remains the same, for Mexico it remains the same, and for Philippines it remains the same. Now let's look at the filing date chart for family based section. F1 category remains exactly the same at 1st of September 2017 for all chargeability China and India. For Mexico and Philippines as well, it remains the same. For F2A category, the dates have progressed a little bit for all chargeability from 1st of April 2025 to 1st of June 2025. Same for China and India, which is good news. Mexico also progressed from 1st of April 2025 to 1st of June 2025, and same for Philippines. F2B category, no change for all chargeability China, India, it stays at 1st of January 2017. For Mexico, it stays at 1st of April 2008, and for Philippines, it stays at 1st of October 2013. F3 category has no change for all chargeability China, India, and also no change for Mexico. However, for Philippines, I am seeing a progression from 1st of December 2004 to 1st of May 2005, which is good news for Philippines. Lot number of people will be able to apply for 485 in the month of September. F4 category is also remains the same for all chargeability China, India, Mexico, and Philippines. All the dates remain the same. Now I heard that there was some wastage of visas in the family-based category, which should have been used up before the end of the year. Unfortunately, if the visa numbers are not used in the family-based category, they spill over into, actually fortunately, they spill over into the employment-based section. So no numbers have been disclosed yet. If there are going to be any visa number spillover, I'll talk about spillovers in a bit. But first, let's look at the final action chart for employment-based category. Now for employment-based category, as you can see, EB1 all chargeability remains same, current. China remains the same at 15th of November 2022. India remains the same at 15th of February 2022. This has been a long spell where India dates for final action chart EB1 have not changed. Mexico and Philippines remains the same, which is current for EB1. Good news is that all chargeability remains current for EB1. So any spillover from rest of the world will flow over onto China and India evenly throughout the year. So that's a good news. EB2, the final action date for all chargeability remains the same at 1st of September 2023. For China, it remains the same. India, it remains the same at 1st of January 2013. Mexico and Philippines also remain the same. EB3, all chargeability remains backlogged at 1st of April 2023. China remains the same. India remains the same. Mexico and Philippines also remain the same. No change in the filing date, final action chart date. Other workers category, exactly the same dates throughout. No changes. The fourth preference category remains unavailable, which means that there are no visa numbers to be given out, so you can't even make any application. Certain religious workers and remains unavailable, and unreserved EB5 remains current for the most part, except the unreserved category for China and India, which is backlogged by about 6 years. Now let's look at the data filing chart for employment based category. Now here, as you can see, EB1 category for all chargeability remains current. China remains same at 1st of January to 2023. India remains the same at 15th of April 2022. Mexico and Philippines remains the same. Now, if you noticed, India's filing date chart for EB1 is 2 months ahead of final action chart. So in theory, before the end of September, before the new year, the dates should progress to 15th of April 2022. But I'm not so super confident on that. So this date really, 15th of April 2022, doesn't mean much to me. Now, if you look at EB2 category, it's backlogged for all chargeability. It remains the same at 15th of November 2023. China, India remain the same. Mexico remain the same, and Philippines remain the same. No change in the dates of filing chart in any of these categories. EB3 also remains exactly the same throughout. Other workers category remains the same. Fourth preference category remains the same. Certain religious workers category remains at 1st February 2021, and all the rest of the chart remains the same. No change in the dates. Now, I want to read out some of the notes that are that USCIS has put out, especially for employment-based section. So if you look at the section D, availability of employment-based visas, there has been a steady increase in both USCIS and Department of State demand patterns for employment-based visas during fiscal year. As a result, visa officer expects to reach FY 2025 category limits in most employment-based preference categories during August and September. So if at any time an annual limit was reached, it would be necessary to immediately make the preference category unavailable, and no further request for numbers would be honored. Now, what they are saying is they will run out of employment-based visas in the month of August or September. So as soon as that date is reached, there will be no further visa numbers available to be given out, and that category will remain unavailable. So which is kind of sad, because it's good and bad. Good in the sense that they are exhausting all the visa numbers, so there are no wastage. There is no wastage of visa numbers, which is good. But bad in the sense that there is going to be a certain period of time in August and September where nobody can apply for the 485 adjustment of status, or no green cards will be issued during that time. Determination of numerical limits on immigrants, they describe the process. Now here's something that you might be interested in. This year, which is fiscal year 2025, which started it back in October 2024 and which will end on 30th of September 2025. For a family-sponsored preference limit, the limit was 226,000. So they did not get any extra visa numbers or anything, which is typical. But for employment-based category, for this year, we had 150,037 visa numbers, so about 150,000. So they were 10,000 more than the regular annual limit of 140,000. So there were 10,000 spillovers from previous year to this year. Not this year to next year, mind you. So we are currently in FY25, which ends in end of September. And until end of September, we have 150,000 visa numbers for employment-based category. Now, I also wanted to talk about, are there going to be any spillovers from family-based category to employment-based category in the new fiscal year, which is going to start on 1st of October 2025? My speculation is that there might be a handful of visa numbers, less than 10,000 visa numbers, spillover from family-based section to employment-based section. That is my speculation. So it's not going to be significantly higher that we thought was going to happen last year. So last year there were about 10,000. This year also, if you're lucky, there might be 10,000. So we'll know that in the upcoming weeks. But what I can say is the fact that EB1 is current for all chargeability, which is rest of the world, which means that any spillovers or any unused visa numbers from rest of the world for EB1 category are directly going to be available for EB1, for India EB1. So I would expect a little bit of a progression of EB1 in October visa bulletin. Now, if you look at purely the numbers, and I made a special video on this last time, if you look purely on the numbers, and as you can see, there are about 3,200 pending visa numbers for EB1 India, which means that to clear this backlog, there are about 2,800 plus spillovers. I would say wash. There will be 1 year of wait time to clear the backlog for EB1 India. So that is my speculation. So the earliest that the final action will move forward is going to be at least a year, but that doesn't mean that they cannot progress the filing chart. So I'm expecting the filing chart for EB1 India to move a little bit further, maybe by 2 or 3 months in October visa bulletin. Now, if you look at EB2, let's look at EB2 remaining or pending numbers for priority date 2013 and 2014. If you look at this, there are about 28,000 pending applicants whose priority dates are in 2013 and 2014, which is incredibly high. So if you apply pure straight line mathematics, it's going to be like 8 to 9 years of wait time just to clear the backlog. Now, this is not that simple. I think there is going to be a progression of 4 to 6 months in the October visa bulletin for EB2 and EB3 India. The reason I say that is there are a lot of duplicate filings. Many people who are standing in queue in EB2 are also standing in queue in EB1 and EB5 and other categories. So they are going to be dropping off. So USCIS will take a chance. They will progress the dates of filing chart, which is what I'm talking about for October visa bulletin, say 4 to 6 months. That is my speculation. We'll see what happens. Don't hold me to it. But this is going to be a very tough battle for EB2 and EB3 India because there is a lot of pending applicants. So if you see pending applicants for EB2, it's 28,000. And let's look at for EB3, it's about 14,000. So EB3 in my speculation is always going to be a little bit ahead of EB2. If you want your green card faster, you might think about downgrading your petition depending on where you are. Not always does it make sense to downgrade the petition, but in certain situations it does make sense. So if you have any questions regarding that, let me know. So for my perspective, EB1 will progress about 2 to 3 months in October visa bulletin in filing date chart, and EB2 and EB3 India will progress about 4 to 6 months in filing date chart for EB2 and EB3 India. That is my speculation. This is just to create the demand, just in case these are just zombie petitions and duplicate petitions that are also pending in other categories through which they will get the immigrant benefit and they will drop out of the queue. So USCIS will apply that logic and they will progress the filing date chart. Now, file action date chart is a different story. It is going to be crawling at snail's pace, and you can expect a long wait just because of the numbers of applicants that we are seeing are pending in those categories. So that's all I wanted to say in this video. Look out for my EB1A masterclass that I will be doing in September. I haven't selected the date yet, but it's the same link in the description. You can go and check it out if you are interested in applying or understanding EB1A criteria and what does that mean. I cannot file your petition, but I can tell you in-depth analysis of what each criteria means, what are the documentation needs, what are the pitfalls to avoid, and so on, and what is the process that you should follow. So check out all the links in the description, and also comment your questions in the section below, because that will give me clues into what topics I need to cover in my upcoming video. And if you have watched my video thus far, a like will be appreciated and a subscribe will be appreciated, and I'll see you in the next one.